Hello and welcome to the Beach House 34 podcast. I'm your host, Christine Worth. A warm welcome to all of you. If you're here, you know that I've covered the Darlie Routier trial transcripts from the very beginning. The mother, who in 1997 was accused and convicted of her 2 children in Rowlett, Texas. If you're brand new here and want to start from the very beginning, you'll find all of the trial transcripts in their very own playlist on YouTube. At this point in time, we have been through the trial transcripts, the appeal, and now we're on the Writ of Habeas Corpus. Now, after this, I'll summarize the motions for DNA testing and what happened, and then move on to some updates. Now, I look forward to getting back to weekly true crime cases, and currently have had to push this date back on those just a little bit. So instead of the 24th of September, I've got somewhere around October 1st to get back on track with those. Now, many of you have asked me to cover other trials, and I am looking into those. In the meantime, though, as soon as something is decided on the trials, I'll definitely let you know. Now, before we begin with this episode, I first want to apologize for being so late in getting this out. As you know, I don't read ahead on these things, and in this case, I probably should have, because in this first part of the writ that was filed, there are a few mentions to affidavits. And if I didn't include these affidavits within this portion of the document itself, I don't believe it would be entirely complete or make complete sense. My initial idea was to go through this whole writ of habeas corpus and then get to the affidavits in a separate episode. But when they popped up in the document, I realized I have to add them here. Not every last affidavit for the defense is included in this document, so I'll add the missing ones at the end of part 2 of the writ. This is part 1. Also, I do not have the state's response to the writ. However, I do have the state's writ exhibits, and those 2 will be added to the second part of this writ of habeas corpus in part 2. So with that said, let's start with part 1 of the Writ of Habeas Corpus for Darlie. I think you might be surprised to learn of some new information that we never heard about in trial. And we begin with the Writ of Habeas Corpus, which was filed, it appears, on December 9th of 2005. And the title, it begins like this: in the United States District Court for the Western District of Texas, San Antonio Division. Darlie Lynn Routier, Petitioner versus Douglas Dretke, Director, Texas Department of Criminal Justice, Institutional Division, also known as the respondent. And then it goes on, petition for a writ of habeas corpus by a person in state custody. And it begins with the introduction. Darlie Lynn Routier sits on Texas death row for a crime she did not commit. On the morning of June 6, 1996, an intruder broke into Miss Routier's household, where she slept on the living room couch. Her 2 oldest boys, Devin 6 and Damon 5, slept near her on the living room floor. Miss Routier's husband, Darin, and their baby boy slept upstairs in the master bedroom. The intruder attacked Miss Routier, Devin, and Damon, brutally the 2 boys, and sliced Miss Routier's throat. Both Devin and Damon died as a result of their injuries. Miss Routier survived, but the state charged her with her son's deaths. A jury convicted Miss Routier of Damon's after the prosecution urged jurors to conclude from circumstantial evidence that she her own sons, inflicted her own wounds, and constructed an elaborately staged crime scene to make it appear as if a third party had broken in. Miss Routier has consistently maintained her innocence. Her conviction at trial turned on the state's presentation of circumstantial evidence, inaccurate expert testimony, and inflammatory character evidence that should not have been admitted. The evidence so infected Miss Routier's trial with unfairness as to deprive her of her right to due process. In addition, Miss Routier's trial counsel failed, among other things, to conduct an investigation of her husband, the only other adult known to be in the house the morning of the represented Miss Routier's husband in a separate gag order proceeding, and then agreed not to implicate her husband in the defense of Miss Routier, and dismissed forensic experts Bart Epstein and Terry Labor after they reached preliminary conclusions that Miss Routier was innocent, and then failed to present any scientific experts in rebuttal of the state's circumstantial case. In Ms. Routier's state habeas proceeding, she filed 7 motions for access to forensic and biological evidence in the state's possession to support her innocence claim. The Texas court refused to hold any hearings and did not rule for over 2 years. The court finally denied Ms. Routier's attempts to gain access to this evidence when it denied her state habeas petition. The court engaged in no independent fact-finding and categorically endorsed the state's erroneous version of the facts. Thus, the state court's conclusions are entitled to no deference. Nor has the state court ruled on Ms. Routier's efforts to obtain DNA testing under Texas law filed in November 2003. Because these DNA proceedings are still pending, Ms. Routier will ask this court to hold her petition in abeyance while she exhausts her remaining state court remedies. Ms. Routier will also exercise her right to seek discovery in federal court. The second point is jurisdiction. This court has subject matter jurisdiction of this case pursuant to 28 U.S.C. 2241D. Ms. Routier was indicted for the offense of capital in the District Court of Dallas County, Texas. Venue was changed for trial to Kerr County, Texas, which is in the Western District of Texas, San Antonio Division. Petitioner is in the custody of the Texas Department of Criminal Justice pursuant to the judgment and death sentence. Under 28 U.S.C. 2244D1, a petition filed on or before December 1, 2005 is timely. Number 3, the statement of facts. In the early morning hours of June 6, 1996, 6-year-old Darin Routier and his 5-year-old brother Damon were in their living room of their home in Rowlett, Texas. Darin and Damon's mother, Darlie Routier, was seriously injured in the same brutal attack, suffering multiple knife wounds, including a cut across her neck that came within millimeters of fatally severing her carotid artery. The immediate aftermath of that assault is captured on the tape of Darlie's phone call to 911, which recorded Darlie's terrified voice saying that an unknown intruder had her and her sons before exiting through the garage. But the investigators who arrived at the house that night almost immediately decided that it was Darlie herself who had her children, and that her near-fatal wounds were only part of an effort to stage the crime scene. The police, and later the prosecution, never wavered from this snap judgment, despite substantial and compelling evidence that an unidentified intruder had in fact been present at the time of the including bloody fingerprints inside the house that do not match any member of the family, as well as a sock bearing the blood and DNA of all 3 victims, which was found 3 houses away in the alley behind the Routier home. It then goes on with A, the attack. Like many victims of violent crime, Darlie does not remember many details from the attack. Darlie, Darin, and Damon had fallen asleep in the family room where they had earlier been watching television. Darlie's husband, Darin Routier, was sleeping upstairs in the couple's bedroom with their youngest son, 8-month-old Drake. As recounted in her trial testimony, Darlie recalls being awakened by Damon hitting her right shoulder and saying, "Mommy," then seeing a man walk from the family room couch into the kitchen. Darlie got up from the couch, then heard the sound of breaking glass. Darlie motioned for Damon to stay behind her, then followed the man into the kitchen and saw him going into the utility room. Darlie turned on the lights in the kitchen, then realized there was blood on her. Walking further, she saw a knife lying on the floor inside the entrance of the utility room. Darlie picked up the knife and placed it on the kitchen counter, then saw that Devin had been and was lying motionless on the floor of the family room. Darlie screamed out Devin's name, then turned to see Damon, who was still standing. Seeing that Damon, too, had been, Darlie screamed out for her husband, Darin. Darin came downstairs and began trying to help Devin, performing CPR. Meanwhile, Darlie got towels from the kitchen to try and stop the boy's bleeding and grabbed the phone to call 911. Darlie put a towel on Damon's back and told him to hold on, to which Damon responded with his final words, "Okay, Mommy." Darlie then moved over to Devin, who was losing blood through his chest wounds every time Darin blew into his son's mouth. After placing another towel on top of Devin's chest wound, Darlie ran outside and screamed across the street for help from a neighbor who was a nurse, then ran back and forth to the kitchen sink for more towels to stop her son's bleeding. All of this occurred while Darlie was on the phone with the 911 dispatcher. When the first police officer arrived at the scene, Darlie was dizzy and using a vacuum cleaner as a crutch to steady herself. Darlie had only realized that she had also been injured in the attack when she saw her neck wound in a mirror, although she did not know how badly she had been wounded. The officer told Darlie to lay down. The paramedics then arrived at the scene and began tending to the two boys. The paramedics first took Damon away and then brought Darlie out to the front porch. After the paramedics bandaged Darlie's neck and arm wounds, they transported her to Baylor Hospital in Dallas, where she underwent surgery to explore and close her wounds. The surgery revealed that the slash wound across Darlie's throat had penetrated all the way to, but not through, the sheath of her carotid artery. Thus, if the wound had been only 2 millimeters longer, Darlie would have bled to death within 2 to 3 minutes. Darlie also suffered severe bruising on both arms that did not fully manifest itself until after the attack. Devin died at the scene. Damon was pronounced dead on arrival at the hospital. Drake, the infant who had been sleeping upstairs with his father, is today 10 years old. Darlie was convicted of capital and sentenced to death. B. The identity of the assailant. In front of the jury, the prosecution neatly summarized the central issue in the case as follows. Quote, "The only issue is who did it. Identity. And it comes down to this. It's either going to be some unknown intruder who came into the house and committed a horrible, or it's going to be the defendant." Unquote. Even before being taken to the hospital by the paramedics, Darlie had described the man she saw leaving through the kitchen, whom she only saw from behind, as having long hair and wearing a baseball cap, a dark t-shirt, and jeans. The investigators quickly disregarded Darlie's description of the attack. James Cron, a retired Rowlett police officer who examined the crime scene that night, testified that he formed a belief that there had been no intruder after his initial walkthrough of the scene, which lasted only 25 to 30 minutes. When asked by the prosecutor why he formed this opinion after his initial walkthrough, Cron mused that, quote, "It's sort of a big picture. It's not any one thing. It was the overall scene, which primarily is the lack of evidence in many cases. But the entire scene indicated to me that there had not been an intruder. There wasn't any one object or any one situation there," unquote. In accordance with this testimony, the state simply disregarded Darlie's account and sought to portray the entire scene, as well as Darlie's own injuries, as an elaborate attempt to stage the scene and cover up Darlie's alleged responsibility for the deaths of her sons. C. Trial. After jury selection, Darlie's trial commenced in Kerrville, Texas on January 6, 1997, exactly 7 months after the of Damon and Devin. The state's case against Darlie was entirely circumstantial, built primarily upon character evidence that Darlie was a materialistic woman who lived beyond her means, and upon the testimony of so-called expert witnesses who testified that the physical evidence at the crime scene suggested that it had been staged. Indeed, the state sought to explain nearly every element of the chaotic, blood-soaked crime scene as evidence of staging, and therefore Darlie's guilt. 1. The state's quote-unquote staged crime scene theory. One of the key items of trial evidence was Darlie's blood-soaked nightshirt, which she was wearing at the time of the attacks. Prosecution witness Tom Bevel testified that blood spatter on the back of the nightshirt was consistent with quote-unquote cast-off stains that would have been deposited when she brought the knife overhead in a motion. Quote, "Taking a knife that was the same diameter of the knife in question, I just simply, in this case, I went down to my knee after placing a clean t-shirt on my body, put blood on the knife on both sides, again, held it up and allowed it to just simply stop its dripping, and then just simply did a motion such as this. I think on the first time I did it with 2 swings, if you would, without adding any additional blood, to see if in fact we get the blood that would be on the back that would be consistent in size, direction, location, as the blood in question on the t-shirt worn by Darlie on the night of the attack." Unquote. He explained the significance of his findings to the jury by saying, quote, "I was able multiple times to get bloodstains that were the same size, location, with the long axis up and down in that area and on other areas of the back of the test shirt," unquote. Thus, the state sought to establish through Bevel's testimony a direct physical link between Darlie and the of her children. But Bevel also conceded that the tiny stains he described as quote-unquote cast-off on Darlie's nightshirt, which supposedly came off of the knife when Darlie was her children contained the blood of both Darlie and the boys. If Darlie had her children, this mixture could only be explained in one of two ways. Either the knife itself had a mixture of Darlie and her son's blood on it at the time she was her children, which was impossible under the state's theory of a staged crime scene, and Darlie's self-infliction of her own wounds after attacking the boys, or millimeter-sized drops of Darlie's own blood must have miraculously landed directly on top of the boys' own millimeter-sized drops of blood. Either explanation defeats the state's theory. Another key element of the state's staging theory was a broken wine glass on the floor of the Routier kitchen, in the middle of the intruder's exit path. Prosecution witness James Cron testified that a glass from a wine rack in the Routier's kitchen had been deliberately thrown to the floor to suggest a struggle. Question: while you were telling us what a rocket scientist could and couldn't do, let me just ask you how you decided that the wine glass was broken. Answer: when I make my walking through the kitchen the first time, I had no earthly idea. I thought, well, maybe it was broken during the scuffle with the intruder. After I finished the walkthrough and went outside and came back inside, it looked to me like it had been broken there to simulate or stage an offense. A member of the household broke it and planted it there. Answer: after I made the initial walkthrough where I first went through, I didn't think anything of it. I thought it was broken maybe in a scuffle. And then another answer: after I went back outside the house, finishing all of the inside, going outside, then coming back in, I based my opinion that there was no intruder, and I could only conclude that the glass was broken as part of the staging of this offense to make it appear like there had been an intruder. Prosecution witness Tom Bevel testified that a Hoover vacuum cleaner that police officers discovered knocked over actually had been rolled through blood as indicated by wheel marks on the flooring, and was another effort to stage the crime scene. Answer: it is a motion just simply of the wheel rolling through the bloodstain. However, they are not connected. You then have another area, and you would just about have to lift the vacuum cleaner and go over to another area and then proceed to roll it again in a different direction from the original location and original direction. Question: okay, so there were differing directions to these movements, is that right? Answer: as well as not being connected. So there has to be some movement up from off of the floor with the vacuum cleaner. Question: the roll marks that you saw on the floor, sir, were they consistent with State's Exhibit number 93 just simply being dumped over or knocked over in one motion? Answer: they would not. No, sir. Another prosecution expert, Charles Lynch, testified that a single fiber recovered from quote-unquote knife number 4, a bread knife, that the state alleged Darlie used to cut a window screen in the garage to make it appear an intruder had gone through the window, was consistent with the material from a torn garage window screen. Question: bottom line, from this comparison of the black rubbery material and the glass rods on the window screen and on this knife, what does this say to you as a trace evidence analyst? Answer: I couldn't tell the difference between this debris and the debris found on the knife, and therefore, this knife could have been used to cause the cut. Defect. In its closing arguments, the state explained how these witnesses' testimony of a staged crime scene supported the theory that Darlie had her sons. Quote: well, it doesn't take Sherlock Holmes to figure out that this vacuum cleaner was dumped on top of those bloody footprints after it was moved. But why? If the defendant did it, it's because it's staging. You need to show some type of struggle occurred, something like that. But what else didn't make sense to Mr. Cron? The wine glass. Supposedly ran into this intruder ran into this wine rack somehow and broke a glass. Well, there's glass on top of the bloody footprints, and the officer said that they were careful not to step on blood and not to step on glass. The trouble is, he checked the wine rack, and it was real sturdy. That is another indication that something wasn't adding up with this story. And when Charles Lynch tested that bread knife, he looked at it under the microscope, and what did he find? Glass rods, the same type of rubber material seen on the bread knife, and that same type of rubber debris with the glass meshed in, the same type of stuff that happens when you cut the screen, and it adds up. That bread knife was used to cut that screen, and that tells you they were trying to fake the crime scene. And the defense asked Tom Bevel how Darlie's blood could be mixed with the boy's blood on the tiny stains on her nightshirt. But the most consistent way it could happen is when the motion comes up and the knife is over the shoulder. He simulated it in tests and found the same size of the spot on his own t-shirt. That tells you that she was, and Devon's blood winds up on her back. It's not going to wind up there if she's laying on the couch as a man wrestles at her neck. The prosecution even managed to incorporate a key piece of evidence found some 75 yards away from the Routier home into the staged crime scene theory that it crafted. That item of evidence was a blood-stained sock found by the police in the alley several houses away from the Routier home, which contained the blood of both Damon and Devon, as well as a faint result of DNA from Darlie and several unidentified limb hairs. The state's explanation for the location of this sock was simply that Darlie must have planted it there as part of her staging of the crime scene after the boys had been. But since none of her blood was found anywhere between the Routier house and the location of the sock, before she supposedly inflicted her own wounds, the state's theory was physically impossible, however, given the testimony of the state's pathologist that Damon could not have lived for more than 9 minutes after being. The 911 recording lasted 5 minutes and 44 seconds, and it was at least another 1 minute and 10 seconds before the paramedic saw Damon take his last breath. This would have left only 2 minutes and 6 seconds for Darlie to, among other things, leave the house with the sock, wearing nothing but a nightshirt, run on concrete in her bare feet to the back gate, kick the broken gate open with her bare foot, run the length of 3 houses, drop the sock, return to the back gate, close the back gate, and enter the house, pick up the butcher knife in her right hand, cut her throat, shoulder, and cheek without turning on a light, switch the knife to her left hand, and cut her right forearm and fingers of her right hand, put the knife with her blood on it down on the carpet near the couch in the family room, move the knife to the kitchen counter, turn on the kitchen light switch with a bloody hand, rush to the utility room and touch the door to the garage with a bloody hand, break a wine glass so that pieces of it landed on top of her blood, grab the vacuum cleaner with a bloody hand, roll it through her blood in the kitchen, lift it off the floor and roll it through her blood again, knock the vacuum over on top of her blood and the broken glass, scream for Darin, and wait for him to rush downstairs and pick up the telephone and call 911. Thus, the only possible explanation for the presence of the sock in the alley was that it had been dropped there by a fleeing assailant. Number 2, the state's trial-by-character-assassination strategy. To bolster its circumstantial evidence of a supposedly staged crime scene, the state relied on a strategy of character assassination, seeking to prove that Darlie was the type of person who would kill her own children. Indeed, the state's trial-by-character-assassination started with the second paragraph of its opening statement, when the prosecution told the jury that, quote, "The real Darlie Routier is, in fact, a self-centered woman, a materialistic woman, and a woman cold enough, in fact, to her own 2 children," unquote. The trial record is replete with character evidence offered and admitted for the purpose of showing Darlie's supposed propensity to her own sons. The following is only a partial list of the evidence and testimony elicited by the state to attack Darlie's character and portray her as the type of person who would kill her own children. Barbara Dovell, a longtime acquaintance of Darlie, provided specific examples as to how, in her opinion, Darlie became more, quote-unquote, materialistic over the years. Dovell was allowed to testify that Darlie had a temper and was the dominant personality vis-a-vis her husband. Dovell was then permitted to describe specific examples of Darlie's temper in response to the prosecutor's question, quote, "What kind of things would get her mad?" unquote, to which Dovell replied, quote, "Mostly money," unquote. The prosecutor intentionally disregarded the motion in limine granted by the trial judge and asked Darin Routier about the fact that Darlie had breast implants. The pastor who presided over the funeral of the slain children was asked irrelevant questions about whether pocket knives and tarot cards were placed in the casket with the boys and whether the song Gangster's Paradise was played at the funeral. The prosecutor asked a Routier neighbor, Karen Neal, wholly irrelevant questions about the lyrics to Gangster's Paradise. Defense counsel offered no objection to admissions of the irrelevant lyrics to the song through this neighbor, and even went so far as to flippantly state in front of the jury, quote, "We have no objection if he'll sing it," unquote. On cross-examination of Luann Black, the prosecutor questioned her about the appropriateness of the lyrics to Gangster's Paradise, the first song played at the children's funeral. Even though the witness proclaimed not to know what the song was about, the prosecution was allowed to ask, quote, "So you are not aware that this is about violent crimes?" unquote. The prosecutor also was allowed to question Darlie's parenting when he asked, quote, "You mean that she let her 5- and 6-year-old children listen to Gangster's Paradise by Coolio?" On cross-examination of Darin Routier, the prosecution was allowed to go line by line through the inflammatory and irrelevant lyrics of Gangster's Paradise. The prosecutor asked Darin Routier about the fact that he and Darlie bought jewelry at pawn shops and even took the children to these pawn shops on occasion. The prosecutor pointed out during Darlie's cross-examination that she did not take her children to church regularly. The prosecutor questioned Darlie about her tradition of going out with girlfriends on the night before Mother's Day. The prosecution, in order to establish that Darlie was materialistic, repeatedly emphasized the material possessions owned by the Routiers. Questioning by the prosecutor regarding the property the Routiers owned, including a, quote, 28-foot boat out there on the lake, new, very nice spa in the backyard, unquote. Prosecutors questioned Darin about his conversations with Jamie Johnson, a child protective service worker, about what Darlie had said to him in 1995 about being, quote, sick of everything, unquote, and having trouble keeping their house clean, and about Darlie being a, quote unquote, cleanaholic. The prosecutor implied through his question that Darin Routier told this individual, quote, "It's kind of an obsession. She will clean and clean, but the kids would be right behind her making bigger messes," unquote. Witnesses with very limited access to Darlie were allowed to testify about her allegedly cold attitude toward Drake, her infant son, after the crime occurred, without establishing any relevance of this attitude to the. For example, nurses who attended to Darlie were allowed to testify that even though she was fitted with IV tubes and had wounds to her neck, she would not hold Drake while she was in the hospital. A paramedic was also permitted to testify that Darlie did not ask about her infant son while the paramedic attended to her. Darin Routier was questioned about irrelevant hearsay statements he had made to a radio show host about people getting caught up in materialism and losing sight of what is important, permitting the prosecutor to ask, quote, "That's right. That is something that you all forgot in 96, isn't it? You and the defendant. You got off the track. You got on the material side of life, and you lost sight of your 2 children for a while, didn't you?" Unquote. Darin was asked to verify hearsay statements that 1, Darlie told him she was disappointed that Drake was not a girl, and 2, Darin said, quote, "There was no time for me and mommy to be sexy or run around the house naked," unquote. In May 1996, quote, "A light went on in my head saying she needs help," unquote. The prosecutor told the jury in closing statements that, quote, "You heard from Barbara Jovel, who is this woman's maid of honor, who has known this woman almost 10 years, who had worked with her every day there at their workplace, their one employee. And what did she tell you? It took a lot of guts to get up there. And she told you some facts about the defendant. She loves the defendant. And a few years ago, Darlie was a very different person. But their business took off and her attitude started changing. She started thinking about money and became more self-centered. You know, she wears the 10 rings on every finger, all the rings and earrings. She started becoming more self-centered, shopping all the time, decorating, buying boats. They bought a spa, they bought new cars, and she is the dominant personality." The next item is, as to a gesture Darlie allegedly made in 1996, the prosecutor was allowed to argue, quote, "You know, I don't think the defendant was going to kill herself. I think she loves herself too much," unquote. Referring to a videotape that was made of Darlie after the at a graveside birthday celebration, the state conceded the real reason it had offered the video. Quote, "I think it gives you a lot of insight into this woman. You see, this is not a picture of a grieving mother, and I don't care how many excuses you can come up with and how many doctors you can bring in here and say this is some type of Christian ceremony, or she was on some Xanax, or people were giving her Valiums. No, you can see how she is acting. She is enjoying herself out there. She likes the attention. She is enjoying it, and it gives you insight into her true character." Unquote. Number 3, evidence that was available but never presented due to trial counsel's failure to investigate and prepare the defense. After her arrest, Darlie was initially represented by 2 court-appointed attorneys, Douglas Parks and Wayne Huff. Less than 3 months before trial, however, attorney Douglas Mulder was hired to replace Parks and Huff as Darlie's defense attorney. Mulder had already represented both Darin Routier and Darlie's mother, Darlie Kee, during a show cause hearing at which the state alleged they had violated a gag order regarding the upcoming trial. Mulder had previously informed Darin and Darlie Kee that Parks and Huff intended to blame Darin for the death of the 2 children. And here it references the Affidavit of Darlie Kee. And this is what it says. It was created on July 12th of 2002. Quote, "My name is Darlie Kee. I am over the age of 21 years old and I reside in Wills Point, Texas. I have never been convicted of a crime and I am capable and fully competent to make this affidavit. I have personal knowledge of the facts stated in this affidavit and those facts are all true and correct. I am the mother of Darlie Lynn Routier, who was accused of by the state of Texas in the capital case of Texas versus Routier. July of 1996, my son-in-law, Darin Routier, and I searched for counsel to represent my daughter in her capital trial. Over the course of my search, various individuals suggested that we retain attorney Douglas Mulder. Darin and I first met Mr. Mulder in July 1996, and we met with him again many times in August of that year. During one of our August meetings, Mr. Mulder told Darin and me that Douglas Parks and Wayne Huff, the court-appointed attorneys for my daughter, intended to blame Darin for the murder of my grandson, Damon. Darin then told Doug Mulder that one of the reasons we were going to retain him was because Doug was not buying into the theory that Darin was involved in this crime. Mr. Mulder assured us that if he was in charge of the case, he would not do that. We decided to hire Mr. Mulder, and he became my daughter's lawyer on October 21st, 1996. We eventually paid him about $95,000. When Darin and Darlie Kee learned of this impending defense, they sought to hire Mulder to defend Darlie in her capital trial. And here it references the affidavit of Darin Routier. And this affidavit was done on July 11th of 2002. And here's what his says. In 1994, I spoke to a person about my Jaguar automobile. In that conversation, I said that, quote, it wouldn't bother me, unquote, if the Jaguar was stolen. The person then stole the Jaguar. In March or April 1996, I asked my father-in-law, Robbie Gene Kee, if he knew anyone who would agree to burglarize my home as part of an insurance scam. I said that I would arrange for my family to be absent from my house at 5801 Eagle Drive, that someone who I would hire would come to the house and take away the furniture and other items from my house in a U-Haul truck, and that I would then pay that person from the proceeds of the resulting insurance payments. Between March 1996 and May 1996, I told multiple people of my planned insurance scam. In the late evening on June 5th, 1996, I had a verbal disagreement with my wife, Darlie Lynn Routier. During that discussion, my wife asked me for a marital separation. I first met with attorney Douglas Mulder in July 1996. I met at least once a week with Mr. Mulder in July 1996. The subject of the meetings was Mr. Mulder's potential representation of my wife, Darlie Lynn Routier, and I in her criminal trial. I continued to meet with Mr. Mulder in August 1996. During one of the meetings I had with Mr. Mulder in August 1996, he told me that the court-appointed attorneys in my wife's case, Wayne Huff and Douglas Parks, had confided in him that they were going to try and portray me as the person guilty of the murder of my sons Damon and Devin because they thought that I had something to do with the deaths of my sons. I told Mr. Mulder that if we hired him, I did not want him to quote-unquote go after me. Mr. Mulder agreed that if hired to represent my wife, He would not argue as part of the defense that I was in any way responsible for the death of my children. Between July 1996 and late September 1996, I continued to meet regularly with Mr. Mulder. On September 30th, 1996, Mr. Mulder represented me at a show cause hearing before Judge Toll, where the state of Texas alleged that I violated a gag order in the criminal case against me to my wife. In September and October 1996, I believe, based on Mr. Mulder's comments to me, that he was my attorney. On October 21st, 1996, Mr. Mulder became lead counsel in my wife's criminal trial." Unquote. As a condition to accepting the representation, Mulder agreed that he would not point the finger at Darin's involvement in the crimes as part of Darlie's defense. During the time that Parks and Huff served as defense counsel, they had retained two forensic scientists, Terry Labor and Barton Epstein, to consult with the defense regarding the physical evidence in the case. And here they reference the affidavit of Terry Labor. And this was done on July 11th of 2002. And his affidavit obviously begins with his introduction, who he is. It also talks about his background, where he currently works at a forensic science laboratory, and talks about the different organizations that he's involved with. And then it gets into the information. And it says, "In August of 1996, I was retained by Douglas Parks and Wayne Huff, then defense counsel to Darlie Lynn Routier, who was then scheduled to be prosecuted for the death of her son, Darin Routier. As part of that engagement, my colleague, Barton Epstein, and I viewed a number of pieces of physical evidence then in the custody of the state of Texas. In August 1996, Barton Epstein and I met with state's forensic analyst Charles Lynch at the Southwestern Institute of Forensic Sciences in Dallas, Texas. We reviewed a number of pieces of physical evidence in Mr. Lynch's possession. We also reviewed evidence in possession of the Rowlett Police Department. Barton Epstein and I recommended to Mr. Parks and Mr. Huff that certain samples of physical evidence that we reviewed be analyzed to test the state's theory that the crime scene at 5801 Eagle Drive, Rowlett, Texas, had been staged. For example, fiber and opaque material said to have been removed from bread knife. We recommend that microscopic and/or elemental comparison tests be conducted on the fiberglass and opaque materials removed from a bread knife to substantiate or dispute the state's theory that the source of these materials was the window screen in the garage of 5801 Eagle Drive, Rowlett, Texas. Other fibers said to have been removed from the knife on the counter. We recommended that the apparent wood fragments and blue fibers removed from the knife found on the kitchen counter be microscopically examined to determine their source. Darlie Routier's nightshirt, based on defects, in other words, cuts, observed on the left side of the nightshirt, we determined that additional testing was required to identify the source of the defects. In addition, we recommend that genetic testing be conducted on several blood-stained areas of the nightshirt. The Hoover vacuum cleaner. Based on our visual examination of the bloodstains found on the Hoover vacuum cleaner, we determined that genetic testing was required to determine the source of the blood. The carpet. We recommended DNA and possible chemical testing of bloodstains and prints left on the carpet from 5801 Eagle Drive, Rowlett, Texas. Darin Routier's blue jeans. We recommended that genetic testing be conducted on several bloodstained areas of Darin Routier's blue jeans. Pillow and furniture. We recommended that genetic testing be conducted on several bloodstained areas on the living room furniture, pillow, and on the wine rack. In late October 1996, Douglas Parks informed Mr. Epstein and I that he had been replaced as defense counsel by Darlie Routier and that we should send him a final bill for our services. Shortly thereafter, Mr. Parks informed us that he had been removed as trial counsel and Douglas Mulder had been substituted as the new trial counsel. In late October or November 1996, I met with Douglas Mulder and his investigator, Lloyd Harrell, to discuss the testing that Barton Epstein and I had conducted to date. Barton Epstein did not attend that meeting. During the meeting, I provided Mr. Mulder and Mr. Harrell with a general overview of the work done to date by Mr. Epstein and I. It was my impression that neither Mr. Mulder nor Mr. Harrell seemed particularly interested in that work. Both men asked me only a few questions. The meeting lasted about 2 hours. Following the meeting, I expected that Douglas Mulder or one of his colleagues would follow up with me because the time in the introductory meeting was not sufficient time to explain in necessary depth the forensic significance of the analysis Barton Epstein and I had performed or had recommended be performed. Mr. Mulder did not retain either Barton Epstein or me to perform any of the testing we recommended, and so we discontinued all work on the case. I had no further involvement in the trial of Darlie Lynn Routier after November 1996. Based on the analysis I performed in this case, it was my professional opinion in November 1996, and is my professional opinion today, that there were numerous pieces of physical evidence we reviewed that were not consistent with a staged crime scene. For example, review of the blood spatter on and near the vacuum cleaner indicated that the vacuum cleaner had not been pushed around by someone bleeding, but instead that most of the bleeding had occurred after the vacuum cleaner had been knocked down. The placement of shards of glass below the location of the wine glasses indicated that the wine glass had broken while still in the rack and was not consistent with a person smashing or throwing the glass onto the floor as part of a staged crime scene. In my professional opinion, scientific testing of the physical evidence would have been critical to Darlie Lynn Routier's defense. Independent testing of that physical evidence was crucial to properly evaluate the state's case. There were numerous potential holes in the state's case that required testing to conform or refute the state's presentation of the evidence, and to provide evidence that could well have refuted the state's forensics testimony. These and other tests would have been critical to developing the physical evidence to refute the state's use of forensic and physical evidence and establish Darlie Lynn Routier's innocence. Based on my blood spatter analysis experience for the theory that direct hits of Darlie Lynn Routier's blood being spattered from her wound precisely covered each blood spatter of her two sons, Damon and Devin, to have been correct would have required an extremely unlikely sequence of events. My preliminary analysis of the shirt Darlie Lynn Routier was wearing indicated only minimal area of blood spatter, and the critical areas of spatter were not subjected to genetic testing. Genetic testing should have been conducted on those blood-stained areas of Darlie Lynn Routier's nightshirt. In addition, a microscopic examination should have been performed to determine the source of cuts observed on the left side of the neck of the nightshirt. Testing of the fiberglass and opaque material, said removed from the bread knife, should have been conducted to substantiate or dispute the state's theory that the source of these materials was the window screen in the garage, and the window screen was cut as part of the staged crime scene. The apparent wood fragments and blue fibers removed from the knife found on the kitchen counter should have been microscopically examined to determine their source. DNA testing should have been performed on the bloodstains found on the Hoover vacuum cleaner to determine the identity of the persons or persons whose blood was on the vacuum cleaner. DNA and possible chemical testing of bloodstains and prints left on carpet and flooring should have been pursued to determine the identity of those who bled or left prints. Genetic testing should have been conducted on several blood-stained areas of Darin Routier's blue jeans, since they might have indicated that he was involved in the Genetic testing should have been conducted on several blood-stained areas on the furniture, pillow, and wine rack to reconstruct the location and movement of individuals at the crime scene. It is my professional opinion that further testing and evaluation of the items referenced above in numbered paragraphs, and these were all numbered 6 to 11, would help establish if in fact the crime scene was or was not staged. Such testing is necessary to confirm or refute the state's testimonial evidence presented at Darlie Routier's trial and to establish Darlie Lynn Routier's innocence. For example, A. DNA testing and or microscopic examination should be conducted on bloodstains left on Darlie Routier's nightshirt, the Hoover vacuum cleaner, furniture items, pillow, wine rack, and all flooring and carpeting samples in the state's custody. B. Chemical testing of the flooring and carpeting samples should also be explored. In addition, all microscopic slides of fibers and other matter removed from 5801 Eagle Drive should be examined to determine their source and/or to rule out possible sources. C. Testing of the brush and powder used to dust the knives in the home at 5801 Eagle Drive should be performed and may refute the theory that fiberglass was consistent with the material from the garage window screen. In order to conduct such testing, access to the above referenced items in the state's custody, as well as samples of the garage window screen and all known blood samples, would be required. Although certain testing might use up a portion of the existing sample, none would destroy the sample completely. Thus, there would be remaining sample for the state to conduct confirmatory testing should it desire to do so. And then it is signed, Terry Labor. Labor and Epstein's preliminary analysis contradicted the state's theory of a staged crime scene. But before Labor and Epstein could complete their work and review of the evidence, Parks and Huff were replaced by Mulder. Mulder held only a brief meeting with Labor regarding the forensic scientist's work on the case, and he did not engage them or any other forensic experts to complete a scientific review and testing of the evidence. This failure allowed the state to present its theory and its expert witnesses to the jury without sufficient rebuttal by the defense. Notwithstanding the state's theory of a staged crime scene, however, there was in fact ample evidence that rebutted and contradicted the state's theory, and that demonstrated Damon, Devin, and Darlie had all been attacked by one or more intruders. Due to Mulder's decision to abandon the defense's own forensic examination of the evidence, the jury never heard any alternative explanations for evidence, such as Darlie's nightshirt, the fiber Charles Lynch found on the bread knife, the broken wine glass, and other critical aspects of the state's physical case. The absence of exculpatory forensic evidence was so glaring that the state even went so far as to point out to the jury that defense counsel had presented no scientific evidence to rebut the physical indications of a staged crime scene. Quote, here is the bottom line on Tom Bevel. Out there at Swift's, there is another expert, Terry Labor. He is the DNA blood spatter expert who went out there on behalf of the defendant also, along with Bart Epstein. And if they want to quarrel with Tom Bevel and tell you that he is wrong and that he is a witch doctor of some sort, where is Terry Labor then? Where is their blood spatter expert? Don't you know that if he had any criticisms of the opinions rendered by Tom Bevel, that just like Bart Epstein, you would see them right up here, and he would be detailing for you what those criticisms are. But he is not here either, is he? And for a very good reason. There is one other thing that we need to ask also. Where are the samples from the t-shirt taken by Terry Labor? Where are they? You remember those first dibs samples that Terry Labor took from the defendant's t-shirt back in August? Before Tom Bevel even had a chance to look at the t-shirt. Terry Labor, the defendant's expert, went to Dallas and was given an opportunity to take several samples from that t-shirt. Did you see those samples in courtroom at any point in this trial? No, you didn't. Don't you wonder why? You really don't have to wonder long about that question. It's obvious to you. Why those best samples taken by the defense, why you never saw them, and why you never heard a test result or a DNA result on any of the samples. It speaks volumes to you sometimes, what you don't see and hear. And it speaks volumes in this case with regards to that t-shirt, unquote. In fact, in October 1996, defense counsel was aware of contrary evidence, but the jury never heard it. Labor and Epstein had concluded that Darlie's nightshirt indicated only minimal areas of blood spatter and that the critical areas of spatter had never been subjected to genetic testing. Bevel explained to the jury that one explanation for the absence of blood spatter was that Damon's and Devin's blood was covered by direct hits of Darlie's blood from her self-inflicted wounds. But in Labor's opinion, that interpretation requires an extremely unlikely sequence of events. Labor and Epstein recommended in October 1996 that the critical areas of blood staining be tested. But Doug Mulder ignored that advice, and the jury never heard evidence from such testing. The jury also never learned that before Charles Lynch tested knife number 4, the kitchen knives recovered from 5801 Eagle Drive already had been dusted for fingerprints using a fiberglass brush composed of a similar material as the fiber removed from that knife. No definitive tests were conducted to determine the source of the fiber. Lynch could testify only that the fiber was quote-unquote consistent with the garage screen window. Lynch had previously reached a similar conclusion about a hair found in the same garage window screen, which he opined was quote-unquote consistent with Darlie's hair. In fact, DNA testing determined that he was wrong. Labor and Epstein had recommended in October of 1996 that definitive testing be conducted on the fiber. But Mulder again ignored their advice, and the jury never heard evidence from such testing. Labor and Epstein also concluded that the dispersal pattern of the broken wine glass conflicted with the state's theory that the glass had been dropped to suggest a struggle. Broken glass shards discovered on the wine rack indicated that the glass had been broken there. Labor and Epstein made that finding in November of 1996. Mulder, however, never presented their finding to the jury. Labor and Epstein concluded that the pattern of blood spatter on the vacuum cleaner indicated that it had occurred after the vacuum cleaner had been knocked down and therefore was not consistent with Bevel's theory that the vacuum cleaner had been pushed around by someone who was bleeding. Labor and Epstein made that finding in November of 1996. Once again, however, Mulder never presented their finding to the jury. Mulder's decision to cut off further forensic investigation also denied the jury the opportunity to properly consider fingerprints that established the presence of an unknown intruder in the Routier home. One of the most significant items of physical evidence that refutes the state's case is a bloody fingerprint, State's Exhibit 85-J, taken from a glass sofa table between the family room where the attacks occurred and the kitchen through which the intruder had fled. The person who left that print would have had to leave it while the blood was still wet. At trial, the state's witness, James Cron, simply testified that he could not make any positive identification of the bloody fingerprint, but that it was quote-unquote small and was, quote, consistent with having been left by a 5 or 6-year-old child, unquote. The state's post-conviction fingerprint expert now concedes that he has excluded, as possible sources of the print, all of the paramedics, police, and other persons who were known to have been at the crime scene between the time the were reported and the time the print was collected, except for Darlie. Yet an independent fingerprint analysis working for ABC News has affirmatively excluded Darlie as the source of Exhibit 85-J, and the renowned forensic anthropologist Richard Janz has testified by affidavit that the fingerprint is consistent with that of a currently unidentified adult. And here they reference the affidavit of Robert Lohnes. And I know they briefly referred to it, but Robert Lohnes was a latent print consultant obtained by ABC News to examine the bloody fingerprint, also known as 85-J. And he says, "My name is Robert C. Lohnes, and I am fully competent to make this affidavit. I am a latent print consultant and attached hereto," and he talks about how he is a latent print consultant and continues and says, "In my capacity as a latent print consultant, ABC News employed me to examine several photographs of latent prints identified to me as being from the criminal case against Darlie Lynn Routier in Dallas, Texas, including State's Exhibit number 85-J. Applying the accepted standards of fingerprint analysis, I compared the photograph of 85-J to the print card of the subject, Darlie Lynn Routier, that is attached here too. It is my opinion that number 85-J was not made by the person from whom the fingerprints on Exhibit B were taken." And here they also reference the affidavit of Richard Janz. And Richard Janz worked for Darlie's appeals attorneys as an anthropological, analyst. He compared the fingerprint 85-J against those available for Damon and Devin. And here is what his affidavit says. "I am a professor at the University of Tennessee Department of Anthropology in Knoxville, Tennessee. In this capacity, I undertook an anthropological analysis of State's Exhibit 85-J from the case styled The State of Texas versus Darlie Lynn Routier to determine, if possible, whether the latent fingerprint reflected in the exhibit was made by an adult or a child. My report of this analysis is attached to this affidavit and incorporated herein. Also attached to this affidavit and incorporated herein is my curriculum vitae. The statements in this affidavit are true and correct. And in these documents, it gives a lot of very detailed technical information about sizes and comparison of pattern ridge breadths of latent prints and so forth and so on. But the conclusion says, quote, the foregoing analysis is able to successfully identify the prints of the two known children, the thumb of Darin Routier and digit 4 from Darin Routier as those of children. The latent print consistently has a higher probability of having been made by an adult. The probabilities range from 0.767 to 0.985, depending upon which character is being used. Obviously, if the print was not made by any member of the Routier family or any of the people who responded to Darlie's 911 call, it had to have been made by an intruder. Thus, Mulder's failure to investigate the forensic evidence allowed the prosecution to falsely argue that Exhibit 85-J was irrelevant and unimportant when in reality it proves that an intruder was in the house at the time of the and left a bloody fingerprint. The bloody fingerprint from the sofa table is not the only unidentified fingerprint connected with the of Darin and Darlie. A second bloody fingerprint was found on the door leading from the Routier's utility room where Darlie found the knife. Though not introduced at trial, this second bloody print also bears enough detail to positively exclude a person as its possible source, and Darlie has been excluded as its source. Darlie and Darin have both also been excluded as the source of another patent print on the same door. Thus, these additional prints were further proof of the presence of an unknown intruder, a fact that could have been shown at trial if Mulder had not shut down the defense's forensic investigation. The jury that convicted Darlie on February 1st, 1997 for the of Darin Routier never heard substantial evidence that undermines the state's circumstantial case against her and supports her claim of innocence. And the jury never heard a key alternate explanation for the crimes because her counsel had agreed as a condition of retention by Darlie's family to protect a more plausible suspect, her husband, at the expense of Darlie's own defense. Darlie Routier now seeks to have her conviction and sentence vacated and a writ of habeas corpus issued because no court can have confidence in such a fundamentally tainted verdict. And then it moves on to Part 4, Procedural History. A. Trial Court. Darlie Lynn Routier was indicted for capital murder on June 28, 1996 in Dallas County, Texas, in connection with the June 6, 1996 death of Darin Routier. On June 28, 1996, the court appointed Douglas Parks and Wayne Huff to represent Miss Routier. Due to pre-trial publicity, a change of venue to Kerr County was granted on September 27, 1996. On October 21, 1996, the court granted a motion to replace court-appointed counsel with Douglas D. Mulder, Curtis D. Glover, Richard C. Mosty, and S. Preston Douglas, Jr. Miss Routier was tried by a jury before the Criminal District Court No. 3 of Dallas County, Texas. Jury selection commenced on October 21, 1996, and was completed on November 18, 1996. The guilt phase of the trial began on January 6, 1997, and the jury returned with a verdict of guilty of capital on February 1, 1997. On February 3, 1997, after hearing evidence during the penalty phase of the trial, the jury returned an affirmative answer to the special issue concerning future dangerousness and a negative answer to the special issue concerning mitigating evidence. Accordingly, under Texas law, Miss Routier was sentenced to death. B. Direct appeal. In March of 1998, the Texas Court of Criminal Appeals held the trial court reporter, Sandra Halsey, in contempt for failing to complete the trial transcript, despite numerous extensions. In April of 1998, Ms. Halsey filed the transcript with the Court of Criminal Appeals. In October of that year, the court ordered Judge Robert Francis to conduct an independent review of the transcript after Ms. Routier's appellate attorneys discovered over 30,000 discrepancies in the transcript. Judge Francis found Halsey's entire record to be so deficient that it had to be replaced entirely. Another court reporter, Susan Simmons, was appointed to prepare, certify, and file a new reporter's record using stenographic notes and Miss Halsey's original transcript. The tapes used by Miss Simmons, however, were often of poor quality and unauthenticated, and Miss Halsey's notes were inaccurate and incomplete. In April of 1999, Miss Simmons testified that she had reconstructed the transcript to the best of her ability. The record was delivered to the Court of Criminal Appeals in December of 1999. Over defense objections, including Simmons' refusal to certify the first 54 pages of Volume 10, which contained the notes of a hearing on October 21st, 1996, at which Douglas Mulder was substituted as Miss Routier's trial counsel, the court issued an order finding that it had complied with all prior orders of the Court of Criminal Appeals and had satisfied petitioner's objections on September 7th, 2000. The conviction and death sentence were affirmed by the Court of Criminal Appeals on May 21, 2003, in a published decision. C. State Habeas Corpus Petition. Ms. Routier's state habeas corpus application was timely filed under applicable state law on July 12, 2002. During the pendency of her state habeas corpus proceeding, Ms. Routier repeatedly moved the court for the right to access and test the evidence that she contends will prove her innocence, including the following. Point 1. Expedited motion for access to state's physical evidence, May 29, 2002. Point 2. Renewed request for access to state's evidence, July 2nd, 2002. Point 3. Post-application motion for access to state's evidence, July 17, 2002. 4. Second renewed request for access to state's evidence, July 29, 2003. 5. Motion for reconsideration, November 3, 2003. 6. Motion for forensic DNA testing, November 4, 2003. And 7. Renewed motion for testing of physical and biological evidence and request for an evidentiary hearing, January 23, 2004. The court did not grant Ms. Routier's motions for access to any of the state's evidence, nor did the court allow any sort of forensic testing. The trial court issued its findings of fact on August 4, 2004, ruling that the petition should be denied. The Texas Court of Criminal Appeals agreed, denying Ms. Routier's petition for a writ of habeas corpus on December 1, 2004. D. Petitioner will request a stay of these proceedings until the state courts resolve her pending DNA testing motions. In connection with her state habeas corpus proceedings, Ms. Routier filed 3 motions that remain pending before the Criminal District Court No. 3 of Dallas County, Texas. 1. Applicant Darlie Lynn Routier's motion for forensic DNA testing, filed November 4, 2003. 2. Applicant Darlie Lynn Routier's supplemental motion for post-conviction DNA testing, filed on January 28, 2005. And 3. Applicant Darlie Lynn Routier's motion for discovery regarding pretrial DNA testing results, filed on January 28, 2005. Collectively, these are called the DNA motions. The state trial court has not yet decided these motions, and the trial court judge has informed counsel for both parties that he intends to resume proceedings regarding the DNA motions in the near future. Out of an abundance of caution, petitioner is filing this petition for writ of habeas corpus less than 1 year after the Texas Court of Criminal Appeals denied her application for a writ of habeas corpus. Nevertheless, proceedings regarding the DNA motions are still ongoing in the state courts, and it is likely to be a significant period of time before the pending motions are finally determined. Petitioner therefore respectfully submits that the time is not yet ripe for this court to proceed to the merits of this petition for writ of habeas corpus by a person in state custody, and will move this court to grant a stay of these federal habeas corpus proceedings until such time as the Texas courts finally determine the matters presented in the 3 pending DNA motions. All right, first of all, this might jump all over the place. I kind of made these notes as the thoughts came to me, and I don't quite know how organized this is, but hopefully it'll make some sense. The first thing that I do want to do is to point out that during each and every one of these readings of these documents, I personally look at the information as it stands at the point in time that the document was created. Now, even though I know a few things have occurred since this document, My opinions, and that's all that they are, my own opinions, are based solely on this snapshot of this moment in time. That being said, we did learn a few things though, didn't we? So we learned that after Darlie's original attorneys were released, because Mulder was now going to step in and be her attorney, the work that Doug Parks and Wayne Huff, her original attorneys, and their forensic investigators, Epstein and Labor, what they had done, Mulder did have a short meeting with them to get them up to date, or to get up to date on what information they had. And then once he had this brief information, he didn't do anything with the evidence that they said they'd found. And why? Well, it was apparent that Darlie's original attorneys were actually going to blame Darin. But part of the agreement with Mulder taking over Darlie's case, who evidently was hired by Darlie's mom, Darlie Kee, and Darin, although Darin denied this during his testimony, this agreement was that if Mulder was able to take over, he couldn't implicate Darin in any way. What I do find interesting, though, is that in Darlie Kee's affidavit, she says that Mulder was the one who mentioned to them that Parks and Huff were going to implicate Darin. I can't help but think that Mulder kind of weaseled his way into this case by giving them this information and then promising to keep Darin's name out of it as a way to get hired by Darlie Kee and Darin. So just think about it. The notoriety of the case, it was going to be on every news station, every television station, likely, and I'm sure worldwide. An attorney may do anything he could to be sure that his name was in the spotlight, or her name, doesn't matter. Then we hear from Darin in his affidavit. And trust me, I get at this point that he's only in his 20s. But even then, you know the difference between right and wrong. And he knows that what he's doing is wrong and could have put him in jail when he arranged to have his Jaguar stolen, which it was. He then admits that he talked to his father-in-law, well, Darlie's stepfather, about having someone come in and burglarize the home at 5801 Eagle Drive, then claim it on insurance, and then pay these people from the insurance proceeds. He said that he would arrange for his family, quote, to be absent, unquote, but he never said a date of when this may have been planned. And I think this is a big piece that was left out about what date this was that he was planning on having this done. He then says he told, quote unquote, multiple people of his, quote, planned insurance scam, unquote, between March of 96 and May of 96. Now remember, the crime occurred in June of 96. He doesn't say who he told or anything other than he just told, quote unquote, multiple people, which in my opinion was pretty stupid, right? If he actually did it at all. I mean, why would you tell? The more people that you tell, the more people know and the more people can turn on you, right? I personally don't think he did. I think he said this just to put further doubt on who actually might be involved in the crime, because then this opens up a whole selection of unknown people who may have been involved in the crime, right? We then finally learn what the discussion was the evening before the crime occurred. I have always felt like there was some big piece of the puzzle missing in this conversation that both Darlie and Darin had the night before the crime. And it makes a big difference, doesn't it? Darin said that Darlie had asked him for a separation. We've never heard this. We don't know what her reasons were for asking for this, but it definitely points to a motive, doesn't it? It explains why she was downstairs. It also makes sense that if Darin was panicked and thought that not only A, was his wife going to leave him, but B, he'd then have to pay not only for Darlie to live elsewhere, but also pay for the kids as well. We already know how he felt about money. I mean, who tries to pull two insurance scams if they aren't after as much money as they can get, right? It 100% points to a motive on Darin's part, even though Darlie swears he wasn't involved. But how can she be so sure if she doesn't even know who it was that attacked her? And did Darlie Kee know at the time that Darlie had wanted a separation from Darin? If she did, do you think that she would have gone along with the agreement to use Mulder and not blame Darin? And not surprisingly, Darin offered all of this information after the fact. Darlie's already been tried. She's already been convicted. She's already been sentenced. Do you think it would have mattered if this was known ahead of time or if the jury heard this information? I believe so, without a doubt. And then again, let's go back to Mulder. Here's Mulder. He's swooping in saying, hey, I've learned this information. They're going to go after you, Darin. Hire me, and I'll be sure your name stays out of it, right? And evidently, he did make sure that Darin's name stayed out of it, because when it came to meet with the analysts for Darlie's original attorneys, the meeting was pretty brief. And Labor, especially, mentioned in his affidavit that Mulder and Harrell, the investigator who, if you recall, wasn't allowed to testify at trial because he was in the audience when Bevel was testifying. Anyway, Labor said in his affidavit that Mulder and Harrell didn't really seem interested in what he had to say. He expected them to follow up with him and Bart Epstein at a later date because this was a very short meeting, but they never did. And of course they didn't. Mulder had already promised not to go after Darin, and Labor and Epstein's testing might have revealed that Darin was in fact involved. But even if we take that out of the picture, just the whole Darin involvement, even if we take that out of the picture, the testing that they had begun and could have completed may very well have cast doubt on the staged crime theory. I am literally blown away that the one man who was supposed to be saving the life of their client would be so dismissive of evidence that might have cast doubt on their client's involvement. Both Labor and Epstein, they had not completed their forensic work, but they did have information that contradicted the state's quote unquote staged crime scene and other information. However, even though they had this information, Mulder never used any of it. And when it came time for Darlie's trial, Mulder, didn't really put up much of a fight when the state had people like Cron and Lynch on the stand talking about the scene and the bloodstain analysis. And again, like I said, I'm going to be jumping all over here and I'm almost done here. But another note that I had is what I find interesting is that in the beginning, Darlie completely denied, or at least was against, the fact that her husband may have been involved. But as I go through this writ, at least so far, it seems to me that at this point, because of this writ, she's willing to kind of give on this part of the argument. Something her original attorneys were going to do in the first place, of course, blame Darin before they were released and Mulder took over. And I'm curious as to why Darlie Kee was so sure that Darin was in fact innocent, or at the very least, that during her daughter's trial, she didn't want Darin's name being brought up. I don't understand that. Then when it comes to the unidentified print, this 85-J, both experts, Lohnes and Janz, agree that it's made by an adult. And when it was tested, it was not Darlie's. There was also a print located on the utility room door that was not even introduced at trial and that didn't match either Darlie or Darin. There is just so much about this trial and this case that is just, it blows your mind how this played out. So that's where we're at this point. We're moving on to part 2 of the writ, and there's actually only one section left, but it's a pretty long section, and that will be in the next episode. And at the end of that episode, like I said, I will read all of the rest of the writs, or these affidavits that were not included or mentioned specifically within this writ. And I'll do that at the end of the next episode in part 2 of the writ. So I'm very interested to see how this ends up, how the final portion ends up. With that said, thank you so much for hanging in there and listening to me. If you do find yourself, coming back time and time again, just consider subscribing to the podcast. If you're on YouTube, just click the subscribe button. It doesn't cost you anything. And then if you want to be notified as soon as new episodes are released, click the bell. Thank you all so much. We will talk very soon. Bye for now.